Good afternoon. This session is on legal methods, and my name is Shazia Khan, and today we'll be looking at learning outcome 3. We looked a little bit at learning outcome last week, so I'm just going to give you a summary of what we did last week in the learning outcome 2, which was to understand the principles of legal interpretation. We looked at the different types of courts. So we had High Court, Crown Court, Magistrates Court, Court of Appeal, Supreme Court. We also looked at the principle of stare decisis and the principle of obiter dicta. We also looked at the doctrine of judicial precedent, the European Court of Justice and what work that court deals with, the Court of Appeal in the criminal and civil division and what they deal with. And we also looked at the High Court, the Crown Courts, County Courts, Magistrates Courts. We also looked at the distinguishing the difference between binding, non-binding and persuasive decisions. And we looked at the advantages and disadvantages of precedent, and also the we looked at the operation of the literal rule, the golden rule and the mischief rule, and the importance of why judges use these rules in regards to cases and what's the importance of that. So each rule we looked at in regards to the different types of cases that dealt with each of the rules. We also looked at the ratio decidendi obiter dicta from legal cases perspective, and we looked at how to find obiter dicta and ratio decidendi in cases. Today we're going to look at understanding learning outcome 3, which is to understand the structure of the legal profession, the judiciary, the jury and the magistrates, and the importance of this. So like we've recapped, the different types of courts, criminal court, Court of Appeal, Crown Court, Magistrates Court, Civil Court, Court of Appeal, High Court and County Courts, the hierarchy of the courts. So we have the tribunals, the county courts, the Chancery Division, the Family Division, the Queen's Bench Division, and the High Court Division, and the Court of Appeal and the Supreme Court, which is the highest court. So 3.1, we're going to look at analysing the structure of the criminal and civil courts. So a court hierarchy establishes which decisions are binding on which courts. There are some exceptions and complications to what follows, but in general, for most purposes, the higher up the court in the hierarchy, the more authoritative its decision. So authoritative in the sense that decisions of the higher courts will bind lower courts to apply the same decided principle. So when we look at this hierarchy of courts, do you think there's a need to have this hierarchy from the lower court up to the higher court?
Yes, but I cannot tell the reason.
No, but why do you think we should have this kind of hierarchy? Do you think so, because all cases can't be heard in one court, can they?
No.
So the most severe cases would be heard in the, the county court and the criminal, the High Court and Supreme Court. The less severe would be heard in like the Magistrates Court. So, the severity of an offence identifies where a court should deal with it. And do you think that's a good thing to have in place?
Yeah, definitely.
Yeah. Because sometimes it's a good thing to have lower courts, because otherwise there'd be so many cases and with one court, and one court wouldn't be able to decide on any of the cases. So the hierarchy actually helps. Like we looked at the structure again. So again, Magistrates Court right at the bottom. You've got the County Court, you've got the Family Court, and then the next one is the Crown Court, High Court, Court of Appeal, and UK Supreme Court. And on the other side, as we mentioned earlier in the last sessions, we've got the tribunal judges for the first tier, employment tribunal judges, England, Wales, and Scotland, and employment tribunal, dealing with anything to do with exclusion of schools, anything to do with legislation, anything to do with, like, for example, unfair dismissal, sexual harassment. They would dealt with the employment tribunal side of it. Criminal justice. Criminal justice cases come to court after a decision has been made by usually the Crown Prosecution Service to prosecute someone for an alleged crime. In the vast majority of cases, over 95%, magistrates hear the evidence and as a panel make a decision on if someone is guilty or innocent. For more serious cases, a district judge, which is a magistrate's court, or circuit judge in Crown Court will hear the evidence. And in the case of the latter, this will involve a jury. Very serious cases such as murder and rape may be heard by a High Court judge. Both magistrates and judges have the power to imprison those convicted of a crime. If the offence is serious enough, but imprisonment is not the only solution, a judge or magistrate can order a community punishment or put an individual under some sort of control over where their movements or activities are restricted. The Court of Appeal Criminal Division. The Lord Chief Justice is the president of the Court of Appeal Criminal Division. He is supported in his role by a vice president. Judges in the criminal division hear appeals in criminal matters from the Crown Court. In the criminal division, the bench usually consists of a Lord or Lady Justice and usually 2 High Court judges. And that diagram identifies the hierarchy again. So High Court judge in the criminal jurisdiction, the High Court judge hears the most serious and sensitive cases in the Crown Court, for example, murder, and some sit with appeal court judges in the criminal division of Court of Appeal. Most High Court judges sit in the Queen's Bench division. They will also deal at first instance with the more serious criminal cases heard in the Crown Court and relatively early in their careers. It can be appointed to hear serious criminal matters in Crown Court centres out of London, known as being on the circuit. Circuit judges for criminal cases. Circuit judges may deal solely with civil, family or criminal work or divide their time between the 3. Most Crown Court judges are heard by Crown Court cases are heard by circuit judges, although less complex or serious matters may be dealt by fee-paid recorders. Some cases from Magistrates' Court will come to the Crown Court to be heard by a circuit judge. For example, if the defendant has opted for trial by jury or the magistrates decide they do not have sufficient sentencing powers to deal with the guilty party, magistrates can impose a maximum 6-month sentence for a single offence with a total of 12 months for multiple offences. The civil court structure. Civil and criminal law differ so much in substance and procedure that they are best administered in separate courts. The civil court structure consists of a magistrates' court, county court, high court, Court of Appeal, Supreme Court of the UK. The magistrates' court, they hear small domestic matters, family proceedings, financial provisions, and care offenders, care orders, custody or adoption. Enforcement of local authority charges and rates. The personnel is district judges, professional paid magistrates who sit alone. Magistrates, justices of the peace, are laypersons selected by the Lord Chancellor, currently Kenneth Clarke. They sit voluntarily and are paid through allowances for loss of earnings, mileage and subsistence. They usually sit in a panel of 3 clerks who provide advice to justices of the peace, particularly on sentencing, and bound by the High Court, the Court of Appeal, Supreme Court and European Court of Justice. It binds no one, not even itself, and its appeals on matters, family matters, are made to the Crown Court with an alternative option to appeal on particular point of law to the family division of the High Court. The County Court. It hears almost every kind of civil case in the majority of UK civil jurisdiction, matters of contract and tort, equitable matters, mortgages and trusts, land disputes, undefended matrimonial cases, probate matters, small claims and fast-track claims. The personnel that work in the County Court are the district judges or circuit judges sitting alone. Circuit judges are senior judges who sit in the Crown Court, County Court and certain specialised subdivisions of the High Court. Part-time circuit judges are known as recorders. usually practicing barrister or solicitor. Circuit judges are below High Court judges but above district judges, and they are bound by the High Court, the Court of Appeal, Supreme Court, and the European Court of Justice. And it binds no one, not even itself. So the appeals, most cases are appealed at the relevant division of the High Court, although some have a direct right of appeal to the civil division of the Court of Appeal. The Crown Court, it hears only a few cases on civil, appeals from Magistrates' Court on matters of affiliation, betting, gaming and licensing. The personnel is High Court judges, the third highest level of judge in England and Wales, circuit judges, recorders, part-time circuit judges, and it's bound by the High Court, Court of Appeal, Supreme Court, and the European Court of Justice. And it binds no one, but its decisions are reported more widely so, are more authoritative, and it appeals to none. The High Court, it hears at the first instance all high-profile, high-value cases, multi-track cases, split into 3 separate divisions: Queen's Bench, Chancery, and Family. Personnel staffed by High Court judges, one usually sitting alone, but in some circumstances, particularly in the Queen's Bench division, are handled before a divisional court. A divisional court sits with at least 2 judges. The usual constitution is 1 Lord Justice of Appeal, Appeal Court judge, and a High Court judge. The divisional court, when a judge sits alone, or all division courts when judges sit together. The Court of Appeal, Supreme Court, European Court of Justice. It binds Magistrates' Court, County Court, Crown Court, and also divisional courts when judges sit together. Appeals are made to the civil division of the Court of Appeal, and in leapfrog procedure direct to the Supreme Court of the UK. Queen's Bench Division. It hears matters of contract law, personnel injury, negligence, etc., and it hears appeals by way of case stated from magistrates, county court, and some from the Crown Court. Its specialised courts of the Queen Bench Division are the Technology and Construction Court, dealing with building, engineering and technology, disputes, the Admiralty Court, dealing with maritime contracts, torts, injuries, etc., the Commercial Court, dealing with any disputes arising from the transactions of trade and commerce, i.e. banking services, import and export of goods, etc. And finally, the Administrative Court, dealing with the disputes concerning the exercise of public power, for example, taxation, child custody, environmental licenses, etc. The President of the Queen's Bench Division is Sir Anthony May. The Chancery Division, this hears matters relating to business law, trust, probate, and land law. It has 2 specialised courts, the Patents Court, dealing with matters relating to intellectual property, and the Companies Court, dealing with matters regulated by the Companies Act, the Financial Services and Markets Act 2002, the Insolvency Act, and the Company Directors Disqualification Act 1986. It hears all tax appeals, and the head of the Chancery Division is the Chancellor to the High Court, currently Sir Andrew Murray. The Family Division, again, this hears with things like matrimonial cases, family property cases, proceedings relating to children, wardship, guardianship, adoption, and it hears appeals from Magistrates' Court and County Court on family matters. President of the Family Division is Sir Nicholas Wall. The Civil Division of the Court of Appeal, this looks at and hears cases from the High Court, county courts, and from other certain tribunals. Employment and immigration. It is the highest court within the senior courts. It may uphold or reverse the decision of an inferior court, or it can order a new trial. The personnel that work in the Civil Division of the Court of Appeal are staffed by the Lord Justices of Appeal, but sometimes High Court and Circuit judges are allowed to sit. Its President of the Court of Appeal, the Master of Rolls, is currently Sir Anthony Clark, who is the head also the head of the civil justice. They are bound by their own decisions, and Supreme Court is subject to exception, and the European Court of Justice. It binds all inferior English courts, which are Magistrates Court, County Court, Crown Court, High Court, and itself, and the appeals lay to the Supreme Court, the highest court. This is the highest court, Supreme Court for the UK. In 2009, the Supreme Court replaced the Appellate Committee of the House of Lords as the highest court in the UK. It hears the role of the Supreme Court is to act as a final appeal court in civil cases in the UK and hears appeals on arguably points of law of general public importance. It's staffed by 12 judges known as Justices of the Supreme Court, including a President, Lord Phillips, and a Deputy President, Lord Hope. The justices are explicitly separate from government and Parliament. Cases are typically heard by panels of 5, 7, or 9 justices who give their decisions collectively rather than individuals. Its own decisions, it's bound by its own decisions and European Court of Justice. It binds all English courts, Magistrates Court, County Court, Crown Court, High Court of Appeal, and itself, and it appeals to none. 3.2, analyse the role of judiciary and the judicial appointment process. The judicial appointment system in England and Wales has been changed with the introduction of the Judicial Appointment Commission. This is the independent and non-departmental public body which was created on April 2006 under Section 61(1) of the Constitutional Reform Act 2005 to be responsible for the selection of the candidates for judicial offices in England and Wales. Historically, that responsibility was solely in the hands of the Lord Chancellor, a government minister, which led to the criticism of the judiciary tend to come from a narrow social background and do not reflect diversity in the population in terms of ethnicity, age, and gender. The Independent Judicial Appointments Commission selects candidates for judicial office on merit through fair and open competition from the widest range of the eligible committees, candidates. Under the Constitutional Reform Act, the JEC will select the candidates for judicial offices solely on merit and people of good character, which is Section 63, and having regard to the encourage diversity in the range of persons available for the selection and appointment for Section 64. The judicial appointment system. Prior to the broad discussion of the appointment process of the two acts prior to the Constitutional Reform Act 2005, namely the Courts and the Legal Services Act, CLC Act 1919, and the Tribunals, Courts and Enforcement Act 2007, need to be considered in brief as the qualifications required to become a judge. The Courts and Legal Services Act 1990 introduced the major changes into the qualification required for fulfilling the position of judges, where the judicial appointment is still essentially dependent upon the rights of that audience in high courts, but the monopoly of the bar to rights of audience in such courts was effectively demolished. It opened up the possibility of achieving judicial office to legal practitioners other than barristers. Section 50 of the TCEA 2007, the judicial appointment eligibility condition introduced a long waiting list of possible candidates for the position of judicial offices in England and Wales, which encourages more diversity in the judiciary. The present judicial system is that the Lords of Appeal and the Lords of Justice are currently appointed by the Queen, at this moment in time the King, on the advice of the Prime Minister, and High Court judges. Circuit judges, recorders and district judges are appointed by the Queen on the advice of the Lord Chancellor, while district judges and lay magistrates are appointed by the Lord Chancellor directly. And above the entire situations in the Judicial Appointment Committee will select the most competent person and recommend to the Lord Chancellor under the Constitutional Reform Act. The Lord Chancellor will continue to recommend individuals for appointment to the judiciary, to the Queen, but no longer will be involved in the recruitment and selection process, because they don't like to get them involved, because they're trying to make the system more fair for everyone, you know, trying to have a system in place that is fair in regards to, you know, trying to, you know, select who they want to select. So, you know, it's really important that they have a fair system in place. The process of appointment. So qualifications of the judges, intellectual capacity, personal qualities, and ability to understand and deal fairly, authority and communication skills, efficiency, and the selection process of judiciary. So judges of Supreme Court, section 26, section 27 to 31, Lord Chief Justice, Master of Rolls and Heads of Division, section 67, section 68 to 75, Lord Justices of Appeal, section 76, section 77 to 84, pursuant judges and holders of offices under Schedule 14, for example, circuit judges, recorders, district judges and tribunal members, section 85. 3.3, analyze the function of the jury in criminal trials. What is the function of a jury? It is their function to assess the credibility of a witness, the measure, the weight that should be given to any piece of evidence, and determine the existence or non-existence of the facts in the case. Once jurors have been called and not challenged, they take the jury oath and are placed in the jury box. What is the role of the jury in criminal trials? Juries are only used in a limited number of civil cases. However, they have a dual role when they are used. The jury will decide upon the facts of the case to find out whether the claimant has proved his case or not. The jury listens to the evidence during a trial, decides what facts the evidence has established, and draws inferences from those facts to form the basis for their decision. The jury decides whether a defendant is guilty or not guilty in criminal cases, and liable or not liable in civil cases. The jury in criminal cases. Although juries are very important in the criminal justice system, they actually deal only with a minority of cases. Criminal offences are classified in 3 categories. Summary offences are the minor offences, and less serious are the tribal only in the magistrates' court. For example, minor traffic offences. The most serious kind of offences is indictable only offences, which must be tried in the Crown Court. Between these extreme kinds, there is another kind of offence called a tribal either way offence. Such cases, as it is clear from the name, can be tried either in the magistrates' court if the magistrates are willing to hear the case and the defendant consents, or in the Crown Court. In these cases, the defendant has the right to insist on being tried in the Crown Court, so either the magistrates or the defendant can opt for a trial in the Crown Court. Where there's a trial in the Crown Court, what will happen, the jury will be there to, you know, assist, okay? So the jury can try a case in the Crown Court, and if the defendant pleads not guilty and the trial proceeds further, he or she will be tried before a jury. The majority of criminal cases are summary only because they are least serious and commonly committed, and as a result, 95% of these cases are heard in the magistrates' court, where the juries have no role. This also includes those cases in which accused pleads guilty in either way offences, meaning out of the remaining 5% of cases heard in the Crown Court, the majority of the cases either defendant pleads guilty, so there's no need of a jury, or the judge directs the jury that the law demands that they acquit the defendant. As a result, the juries actually decide only around 1% of the criminal cases. But on the other hand, this 1% amounts to 30,000 trials, and these are the most serious ones come before the court. It is very difficult to answer that why defendants opt for Crown Court trial instead of magistrates trial court, but research shows that there is a perception that there are more chances of acquittal before a jury than before a magistrate. This perception is borne out of by statistic evidence to show acquittal rates of approximately 40% in jury trials as compared with 25% in magistrates' court. 3M1, so this is additional ones, to analyse parliamentary and governmental efforts to widen access to the legal profession. Here you need to study the Constitutional Reform Act. What does the Constitutional Reform Act do? The Constitutional Reform Act modifies the office of the Lord Chancellor and makes changes to the way in which some of the functions vested in the offices are to be exercised. The Act also creates the Supreme Court of the UK and abolishes the appellate jurisdiction of the House of Lords. And you need to read the additional handouts that are provided on Moodle. And if you can just email them to get access of Moodle, then you'll be able to, read that.
Okay.
The Hazel Green Report. This study, the handout again, is on Moodle constitutional reform process. Where did the Legal Services Act do? The Legal Services Act 2007 is an act of Parliament of the UK that seeks to liberalise and regulate the market for legal services in England and Wales, to encourage more competition and to provide a new route for the consumer complaints. Current LTR review is on Moodle, and that's the link to it that you can go to the report, okay?
Okay.
Compare and contrast the benefits and drawbacks of the different types of alternative dispute resolution, and that's AC3M2. Here you need to do a table for the advantages and disadvantages of alternative dispute resolution, and the article you need to have a look at is on here, which is on your slides. And the article you need to look at in regards to it is advantages and disadvantages on here. Can you see the article that I've just brought up?
Yes, I can see.
Yeah, so have a read of that article in your own time, and for next week, please look at the advantages and disadvantages, okay?
Oh.
So a little bit on a quiz. What did the Constitutional Reform Act do? The Constitutional Reform Act was an act of Parliament that was divided into three parts. The first reformed the House of Lord Chancellor's position. The second created and set the framework for the UK Supreme Court. And third regulates the appointment of judges. What is the Legal Services Act 2007? The Legal Services Act 2007 is an act of Parliament of the UK that seeks to liberalise and regulate the market for legal services in England and Wales, and to encourage more competition and to provide a new route for consumer complaints. And what is the Legal Education and Training Review? That's an education and training requirements, regulated tools to ensure that individuals and firms must meet the standards of professional and ethical competencies required across the workforce. As the nature of the service delivery in the legal sector has changed, training requirements had remained broadly the same. This has created a disconnect between education and practice. The LSB engaged with the review of the education held by the Solicitors Regulation Authority, the Bar Standards Board, and the ILEX Provision Standards. The review, the first of its scale since 1971, delivers a strategic assessment of the needs of the workforce in 2020 and was published in 2013. Some of the references are all here that you can look at in regards to this. Judiciary.uk, and the Corporate Business Law, Law Teacher, Open EDU for them. Then we've got the European Court of Human Rights. The European Court of Human Rights is the Supreme Court for those European states that have signed up to the European Convention on Human Rights, currently all except Belarus. It was established in France in 1959, the aftermath of World War II, and it aims to protect the civil and political rights of citizens. It will hear cases when all domestic legal avenues have been exhausted. Any individual that alleges that their human rights have been violated can bring an action against those responsible. And since the Human Rights Act 1998, the UK has incorporated the European Convention on Human Rights into UK law. One judge per state has signed to the convention, currently 46, currently led by President Jean-Claude Costa, France one. The European Court of Justice, the highest court, Supreme Court in the European Union in matters of EU law. tasked with interpreting EU law and ensuring it's applied fairly and equally across all EU member states. It's based in Luxembourg and established in 1952, 1 judge per member state, currently 27. It normally hears cases in panels of 3, 5 or 13 judges and currently led by President Vasilos Skoursis in Greece. The Privy Council, the Judicial Committee of the Privy Council is the final court of appeal for certain Commonwealth countries, UK overseas territories and Crown dependencies. It was established in 1833 to hear appeals formally made to the King. One of the oldest parts of the government and its current president is Nick Clegg. The Judicial Committee consists of the US Supreme Court justices and some Commonwealth judges. Tribunals. Tribunals deal with a large number of cases deemed too small to be considered as needing court action. In 2009, the Tribunals, Courts and Enforcement Act introduced reforms to build a unified system with recognised judicial authority, routes of appeal and regulatory supervision. They introduced a 2-tier tribunal system. The first tier hears tribunals and makes decisions. It is made up of 6 chambers: General Regulatory Chamber, Social Entitlement Chamber, Health, Education and Social Care Chamber, Tax Chamber, War Pensions and Armed Forces Compensation Chamber, Immigration and Asylum Chamber, and appeals from the first tier can be made to the upper tier, but only with permission. The upper tier. It handles the appeals against decisions of lower tribunals and has the equivalent status to the High Court. It is split into 4 chambers: Administrative Chamber, Tax Chamber, Lords Chamber, Lands Chamber, Immigration Asylum Chambers. Appeals from upper tribunals are to the courts, which is the Court of Appeal. And the reason they have the different chambers is they all deal with something specialist in that area.
Okay.
Employment Tribunal deals with employment issues, are governed by the number of regulations, including the Employment Tribunals Regulations 2004 and the Employment Act 2008. It hears cases involving employment disputes that have not been resolved by other means. This kind of tribunal is less formal than a court hearing, but the decisions are legally binding. Each tribunal is staffed by 3, an employment judge and 2 non-legal members selected from a panel. 1 person represents the interests of the employee and the other, the employer, right of appeal, usually on points of law, not facts, is to the Employment Appeals Tribunal, EAT, which has equal status to the High Court. For example, EAT there's a right of appeal to the Crown Court if it will not re-examine the facts. So, you know, the reasoning behind having so much different tribunals and courts is that they may be specialists in that area, but sometimes, you know, the inferior courts will deal with the less severe stuff, and the more superior courts will deal with the more superior stuff. Things like, you know, for example, if there's been cases of murder, or there've been any other cases in regards to rape or anything like that, then they would have them deal with it in that way. Okay. Have you got any questions around that, Jacqueline?
No, not yet.
So if you need to get anything on Moodle in regards to that, did you manage to do them, look at them cases from last session?
No, I couldn't.
No, that's okay. You can do it for the next session. Okay. So don't worry about that. But I need you to try and email UK Varsity and then try and get some access to Moodle then. Okay.
Okay.
Have you got any questions, Jacqueline, before we finish?
No, I've got no questions today.
Okay. So the next session we've got is Learning Outcome 4. And that will be next week, which we'll be looking at understanding civil and criminal justice system and the alternative disputes resolution. Okay, so we look at the different methods of mediation and things like that.
Okay.
Okay, so if
Okay.
you've got no questions, we'll finish off the session today.
Mhm.
And what I'll do is, if you can email me, so
Okay.
don't email UK Varsity or Victor in
Yeah.
regards to getting some access to onto Moodle, and then what I'll do is I'll see you next week, so you can get, if you can try and get some access to the resources and things.
All right, I'll do that.
Okay, so
Okay.
if you can